Maybe he's gonna walk in at 6:30. If there were people here, I would say yeah. But since there's no people in the audience, maybe it's not so critical.
Something.
I now call this meeting of the Safety Harbor Code Enforcement Board to order this 18th day of October, 2023 at 6:30 PM. Ladies and gentlemen, the City of Safety Harbor Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. In order to meet that obligation, all parties or their representatives will be allowed a full opportunity to be heard on all matters relevant to the alleged violation. All parties and their representatives or witnesses offering testimony or presenting evidence will be required to swear or affirm that the testimony they provide is the truth. The order of presentation will begin with the city presenting their evidence of the alleged violation. The respondents shall then present their case following the conclusion of the city's presentation. Both parties shall have an opportunity to cross-examine all witnesses called by the opposing party. The board and its attorney may question any party or witnesses called to testify by either party. Upon completion of the evidentiary phase, both sides are allowed an opportunity to summarize their respective cases. The board will then openly deliberate, considering only the evidence presented, the law, and common knowledge. By motion, an order approved by at least 4 members of the board will be issued, and within 10 days reduced to writing and mailed to the respondent. The order will contain findings of fact, conclusions of law, and affirmative relief to be taken. In a few moments, the code enforcement clerk will announce the names of the cases as listed on our agenda. When you hear your case called, please respond by coming to the podium with your representative or any witnesses to be sworn in. Ms. Bandy, will you please call the roll?
Yes. Beth Cardenas. Carmen Lundy.
Here.
Miguel Hicks.
Here.
Christina Jackson.
Here.
Jeff Dahl.
Here.
Tom Shea.
Here.
Brian Hack.
Here.
Wonderful, and welcome, Mr. Hack. Very excited to have a new alternate member who is sitting in this evening for Ms. Holly. So thank you very much. Appreciate your service. And then also, we have minutes here in front of us from our last meeting. It's been a few months, August 16th, 2023. May I please have a motion for the approval of these minutes?
Motion to approve the minutes from the meeting of August 16th, 2023.
Chair recognizes Mr. Hicks' motion. May I have a second?
I'll second.
Okay. Chair recognizes the second from Mr. Shea. All in favor?
Aye.
Okay, motion passes 7-0. Let the record state. Okay, so on our agenda, I know we have 2 cases to go over, but since we have a gentleman here present for one of our non-compliance hearings, I would like to go ahead and move that up on the agenda, if that's okay with you, Ms. Bandy and Mr. Trask.
I just need to swear in everybody. before
We can
get
do that?
started.
Okay.
Okay.
So we'll go ahead and proceed with swearing you in.
All right, anyone that's going to speak, stand up, raise your right hand. You swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? Okay, thank you. Okay.
Very good. Okay. Ms.
Okay.
Bandy, if you'll call that case forward, please.
Sure. So we're going to go to the second non-compliance hearing, CEB 23-0175, City of Safety Harbor versus Samuel K. Harris, 160 Joyce Street.
Good evening, this is a non-compliance hearing for 160 Joyce Street, case number 23-0175. I'd like to present the affidavit of non-compliance with the USPS proof of mailing.
Paul, can you introduce yourself?
Oh, I'm sorry, my name is Paul Wishy, City of Safety Harbor Community Compliance Officer. And I'll start at the beginning. the affidavit of noncompliance, USPS proof of mailing, board order, the notice of hearing, the affidavit of posting, and the USPS proof of mailing for that, for the notice, for the affidavit of posting as well.
Any objections?
No.
Okay, board accepts. Okay.
Ms. Jackson, we do have somebody here who would like to speak on this.
For this case?
Yes,
Okay, we'd like to get him sworn in.
he's the attorney.
Yeah, the attorney has already been sworn in.
Okay, so the gentleman that just walked in is not speaking on this case?
No,
Oh, okay, I misunderstood.
I'm sorry.
I saw you walk up and talk to him, so I thought he was for this case. Okay. Yes, so if you would like to come in and speak, you may come to the,
Mr. Bush, you done?
you're done, Mr. Bushy? There's nothing you'd like to say? Yes.
Well, Kent Runnels, 531 Main Street, Suite F, Safety Harbor. Counsel for Harris, the owner of the property you called here last time. Just to reiterate the facts, and then Paul was actually out there today, so I was just going to ask him what he saw when he was out there. But if you recall, Mr. Harris bought this property as it is. The contract, when he bought it, the only way he could buy it was to give the seller 90 days on the property. I came down here, we went back to the seller, we were able to reduce him to shorten that time to about September 15th. So as soon as Mr. Harris could, he moved forward as quickly as he could. Did a bunch of the initial cleanup that could be done without a permit, demo permit, stuff like that. Then he got his demo permit October 16th. The machine was out there today, the backhoe or whatever you call that big thing. Demolition is well underway, cleaned up as much as he could, as quickly as he could. And I just asked Paul, who was out there today, what he saw, because I didn't go look at it myself.
Okay.
They have started the demo.
But we're still in non-compliance.
We're still in noncompliance.
But it takes a couple days to clean it up. Hearing was next week, we would be able to say we were in compliance, but it's not. That's all I have.
Thank you, Mr. Reynolds. Anything else to add? Very good. Okay, at this time, no public input. We're on affidavit of non-compliance. Do we have a motion on the case?
I got a question. Mr. Trask, can we extend the timeline for compliance or non-compliance?
Yes, the answer is yes. You can do that if you want. You can either accept the affidavit of non-compliance, which is being presented to you tonight, or there would be a motion to extend the compliance date.
Okay.
But we need to hear from the city on that, if there's been that request.
Does the city have any recommendations or concerns?
We have no objections with an extension.
Then I move to extend the motion of, or the
Compliance
notice
date.
compliance date to,
I thought they had to September 14th, and they were being charged $250.
we skipped two meetings. Yeah, we skipped two meetings. I'm motion to or move the compliance date to November 6th, 2023.
Okay?
Okay, second?
I'll second.
Okay, so motion first by Mr. Hicks to extend or to update the original compliance date to the 6th. And we have a second by Mr. Shea. We could have a discussion if we would like to at this point.
Yeah, sure, I'll let you know my reasoning for that. I'd like to, thank Mr. Harris for cleaning up what was a very dangerous situation and a dangerous household. I don't know if you remember this, but this is the one where the drill battery caught on fire and there was flammable liquids, and the fire department said they wouldn't go in there because it just poses too great a threat to to staff and people there. So I think we should show some leniency here and extend the compliance date for that reason.
That's same reasoning I have.
Okay. Okay, we'll do a roll call vote, please, Ms. Mandy?
Okay, Beth Cardenas? Aye. Carmen Lundy,
Aye.
Miguel Hicks?
Aye.
Christina Jackson?
Aye.
Jeff Dahl?
Aye.
Tom Shea?
Aye.
Brian Hack?
Aye.
Okay, motion passes 7-0. Do you need a summary on that? Would you like a summary?
November 6th is what I heard, right?
November 6th, yes.
Yeah, that machine that sits out there is really expensive, so he's gonna get it done as quickly as he can. And we really appreciate the extra time.
Okay,
So we'll keep moving as quick as we can.
okay,
Okay, thank you very much.
Thank you.
thank you. Okay,
Next case coming up. Yes, Chris.
All right.
Mr. Bushy, do you know which case he is here for? Is it number 1? Okay, you can, okay, very good.
All right, we're gonna go back up to new business. It's the first case under new business. CEB 23-0258, City of Safety Harbor versus Ike Evans, 660 Pine Street, repeat.
Sir, if you're going to be testifying, I need to swear you in. If you could stand up, raise your right hand, I need to swear you under oath. You swear that the testimony you're about to give tonight is going to be the truth, the whole truth, and nothing but the truth? Okay, that's okay. You're fine. Thank you.
Good evening, my name is Paul Bushy, Community Compliance Officer for the City of Safety Harbor. I am state certified in the fundamentals of code enforcement, administrative aspects of code enforcement, and the legal aspects of code enforcement. This case, number 23-0258, involves a property at 660 Pine Street, Safety Harbor, Florida. The city offers printouts of the entry of this property from the Pinellas County Tax Collector and property appraisers' websites and evidence. The printouts show the property is owned by Ike Evans. This is not a homestead property. There are no objections.
okay, court accepts, thank you.
August 11, 2023, in response to a resident's complaint, I investigated subject property. There were significant quantities of junk, trash, and debris on the property, as well as more than one trailer parked on the property. The junk, trash, and debris and multiple trailers remain on the property as of this morning, October 18, 2023. This is a repeat violation. On December 15, 2021, the Safety Harbor Code Enforcement did find a respondent in violation of Section 5.26, sub 1 and 4, and Section 2312, subsection C of the Safety Harbor Code of Ordinances. The board then accepted an affidavit of noncompliance and an affidavit of compliance at its August 3rd, 2022 meeting. Florida State Statute, Chapter 162.092A reads in part, a fine imposed pursuant to this section shall not exceed $250 per day for a first violation and shall not exceed $500 per day for a repeat violation. In section 162.06, sub 3 reads in part, if a repeat violation is found, the code inspector shall notify the violator, but is not required to give the violator a reasonable time to correct the violation. A notice of repeat violation was mailed to the property owner on August 18, 2023. The notice provided the appropriate code sections and included the fact that these are repeat violations. I also spoke to Mr. Evans, the property owner, on August 11, 2023, and asked him to clean the property, warning him of the repeat violation status. When little was done towards compliance, a notice of repeat violation was mailed USPS certified for the copy mailed first class. This has been an ongoing issue in the neighborhood affecting quality of life and property values. As stated, the board did previously find the respondent in violation of the listed ordinances. The city accepted a lien reduction application on August 22, 2022, and the city manager approved a lien reduction of $1,334.74, leaving only the $410 prosecution costs to be paid by the respondent. These costs were paid on October 6, 2022. With the board's approval, I'd like to present some photos of the property, the December 15, 2021 board order, and the affidavits of non-compliance and non-compliance.
Liz, I changed that exhibit. You marked 2, exhibits number 1. So we're going to have the property appraisers as number 1, tax collector as exhibit number 2. it's not a repeat violation on what, 526, 1 of 4. Okay, so this needs to go over there in that other stack. then. The evidence is coming up. Okay. Any objection to that, sir?
The board accepts.
What are the documents he's reviewing right now?
He's looking at the December 15, 2021 board orders and the affidavits of compliance and non-compliance.
Okay. Okay.
But it was December 2021?
Yes.
Oh, there it is, number 3.
Sir, do you have any objections to those documents? Okay.
The board accepts.
This property has existed on 8/18, the date of the notice of violation, and you'll see we have 2 recreational vehicles in violation of 2312. You see some debris here. Further to the back of the property, got quite a bit of debris through here, and there's more behind this fence. Over third, we still have trailers being brought in with all kinds of stuff in them. Still debris in the driveway remains. This is the back behind that fence, and it's pretty much a working scrapyard. Still on 10-3 at the front of the property. These are dated 10-6. And 16. And again, we have the multiple trailers, quite a bit of debris through the front. This morning. See the multiple trailers still exist, still have the dump trash and debris. Notice of violation was mailed, USPS certified, and a copy was mailed USPS First Class notifying the property owner of the violations on August 18, 2023. The notice included the appropriate code sections and the notice that these are repeat violations subject to referral to the Code Enforcement Board. The city office did notice of repeat violation and the USPS proof of mailing into evidence with the board's approval.
Any objections? Mr. Bushy, did he have an objection?
Any objections, Mr. Evans?
Board accepts.
On October 6th, 2023, more than 10 days prior to today, Code Enforcement Board Clerk Elizabeth Bandy mailed a notice of hearing to Ike Evans, certified mail, with an additional copy mailed USPS First Class. A copy of this notice was also posted at the property, and an additional copy was posted at City Hall. The notice cited the appropriate code sections and the date of the hearing. The city offers the affidavit of posting, the notice of hearing, and the USPS proof of mailing into evidence.
Any objections to those documents, Mr. Evans? Okay.
Board accepts.
The property remains in violation as of this morning, October 18, 2023. Costs to prosecute include at least 9 hours of the code compliance officer's time and at least 16 hours of the code enforcement board clerk's time, for total prosecution costs of at least $410. The city asked the code enforcement board to find the property owner, Ike Evans, in repeat violation of section 5.26, subsection 1 and 4, and section 23.12, subsection C of the Safety Harbor Code of Ordinances. It is the staff recommendation that in addition to the prosecution costs of $410, the city asks the board to find the respondent in a repeat violation of the above ordinances and order a fine of $250 per day, starting on August 18, 2023, and continuing until the property has been brought into compliance. Thank you.
Sorry, Mr. Bush, did you say August 18?
August 18th, that's the day
So
that,
post dated back to the August.
per
Okay.
statute, there's no
Okay.
notice required to give. And the respondent is here tonight, would like to speak to the board. I don't know if he has any questions for me.
Mr. Bushy, questions for you from the board? The initial, we can have questions to him
Yeah. Well, as soon as he gets up and presents his case.
for Mr. Bushy, okay. In his test, just a clarifying question.
Yeah. Otherwise, you can do the cross-examination if there are any questions.
Yeah. I didn't catch the date of your first inspection on this case.
That was August 11th.
It was, okay, because I had that you spoke to him on August 11th, so that was the day that you also inspected the home?
Yes, that was the first inspection.
Okay, because the resident complaint came in on what day?
I believe it was the 11th.
So the same day of the complaint, you also spoke to him at the residence and inspected at the residence, all on the same day?
On the same day.
He happened to be there, even though he doesn't live there?
No, I called him.
Called him. So you didn't inspect the home on the 11th?
I did go by the home and saw the violations on the 11th and gave him some time to get started on cleaning up, and when there were no efforts,
Okay,
we did refer to the board as repeat violation.
okay. Just wanted to make sure I got it all right on the 11th. There was so, just to make sure before I lost it.
Understood.
Thank you.
I have a question. Oh, okay. Mr. Bushy, you stated that on 6/27, a notice of non-compliance was issued by the city, right?
I would have to confirm those dates, but I believe that was correct. He was out of compliance for approximately 20 some odd days. I don't have that information right in front of me, but
And then on July 11th, a notice of compliance was in the packet as well. What was he in compliance of? Because a lot of that debris didn't look like it moved.
the debris was moved,
All of it, including the backyard.
including backyard. Yeah, he got it substantially cleaned up, and I think the vehicle was remaining.
Okay, so,
We didn't cite the vehicle.
okay, so this is all new stuff that's
It
been
does,
brought
to me,
in?
appear to be all new stuff. I don't,
Okay. Okay, thank you.
it does,
Yeah.
it does appear to change, especially in the front yard. I've seen different things kind of come and go.
Okay, thank you.
Thank you.
Thank you.
We'll do cross later. Okay.
Yes, my name is Ike Evans, and I live at 660 Town Street.
You live there now?
Yes. But I haven't had my mail changed yet. That address changed, and I didn't get a chance to get my mail for late. But he said he called me on the 11th, August the 11th.
Yes,
And you came out there, you didn't take any pictures that day, did you?
I did not. The 18th.
And you said I hadn't did anything? since Thursday. I cleaned up some of the stuff. My job.
I just observed a significant amount of debris there, and it didn't appear that anything had been done.
I do recycling, that's why it's like that. I cleaned up, but I'm gonna work on it again. And I just like to know what's my damage gonna be.
So this is your opportunity to state your side of the case. This is a new hearing for a repeat violation. It's brand new compared to what happened in 2001. So this is your opportunity to talk to the board about this particular situation. I do have the minutes pulled up in front of me on what took place that time, so I am familiar about your profession. And at that time, you had told the board that you did not live at that property and at that residence. So you now live there.
Now I'm just there, so
Okay,
I'm going through
okay,
a situation at my old address, so
okay.
that's why I moved back there. I made my, a lot of the problems.
But you did know about tonight's hearing and you did speak to
Yes,
Mr.
I
Bushy on
know.
the 11th?
Yes.
Okay, for the record. Okay, very good. Is there anything that you would like to tell the board in terms of the situation? And the
First,
code?
the cleanup parts about the voting stuff, that I got rid of the voting stuff, some of the stuff I got. The trailers I move and bring back, but, you know, you said not allowed to have a 2 trailer or 1 trailer. How many trailers you allowed to have?
You can have one registered trailer on your property.
All right.
And then in terms of junk and removals, you have 5 days within the code limits to have that, you know, taken out with trash. So basically, you can't run a scrapyard business, you know, within the home. Yeah, and we talked about that in 2021.
Just say if I like, if the fence in, you have to look over the fence, is, you know, how is that, you know, how did the good fence something in? It's not gonna look over and see into it.
Well, it's not just about looking over. It
Isn't
has to,
that supposed to look like privacy, a privacy fence?
yeah, I mean, you can see it from the road, but it also has to do with the code, with, you know, rodents and, you know, safe conditions and all of that within the code too. So there's more than just, you know, safe habitable places within the code.
So what am I finding gonna be?
Well, we haven't talked about that yet.
If I not get charged so much or whatever, but give me so many days to clean it up, I have to clean it up. I have to again. So I'm going, in the process of going through divorce right now, separation, so. That's not none of y'all business, but that's one of my.
Do you have anything else, in terms of timing, anything like that you'd like to share with us to get it cleaned up, or how you think you would get it cleaned up?
I know I'm gonna get it cleaned up, but I don't know how much time how much time can y'all give me?
How would you go about cleaning it up?
Cause I have a trailer, a big large trailer. It's not parked there, but it's parked somewhere else. And I just go through that and put it all on there. I won't be able to do it overnight, but it's gonna take me some time.
About how much time? Is there anything else you'd like to share with the board in your testimony?
I'll say, but to the first of the year, 2024, I know that's more than 2 months, that's what, 3 months? Or the holidays and stuff coming up, so. That's good.
That concludes your testimony. We'll ask of the city their thoughts on it.
So, sir, you can have a seat right now. You can have a seat.
Yep. At this point, if the city has any comments that they would like to make after hearing his testimony?
We wouldn't have an objection to giving the respondent some time to clean up, but we feel like the amount of time he's requesting is excessive. We believe 2 to 3 weeks would be sufficient to clean up the property and come into compliance.
Okay.
Thank you.
Okay. Any other comments other than that?
I would ask the board, because this is repeat and it's a significant eyesore within the community, that if you were to offer more time and he doesn't get this accomplished, then we go back to the original August 18th date to start the fines. We need a pretty strong incentive. This is not the first time we've heard of these violations.
Okay. Kind of went off a little bit on that, just
Okay.
because of the situation with our respondent. So we do have a question for the respondent, so is it okay to
Mr.
bring him
Evans, can
back
you-
up?
Can you step back up here? There's questions from the board.
Hi, so Mr. Evans, okay, so I think the number one problem here is you cleaned up the yard and everything prior, correct? And then you brought more stuff to scrap. I think the reason or the root cause here is you're operating that business out of what should be a home, right? Is there any way you can move your business elsewhere, or is there any way you can relocate your business? I know money is a constraint, but,
But the first year I'm planning on getting out of this recycling business. And
you're not.
that's the first year.
As-
I'm getting old and I know.
Okay. So you're ending your recycling business and your hauling business and all of that?
Not my hauling business, but my recycling business.
Okay. So you will not be operating the recycling, salvaging part of your business
Hopefully for the first year.
as of the first of the year? Okay, because that seems to be the cause of you coming back, you're being reported.
That's the cause of it.
And the board is, I mean, I'm struggling with trying to come up with a way to craft something that leaves you in compliance, that you can meet, and also addresses some of the safety hazards and issues, because I saw diesel fuel cans and gasoline cans out there, and the last time you were before the board, there were a bunch of 55-gallon drums of, we don't know what, out there. Well, we don't know what it is. We have no way of knowing, right? Okay. And that's a real concern, because once that leaks into the groundwater and it contaminates the ground, and then pretty soon you have, contaminated area where children and families are supposed to be, not where a scrapyard is supposed to be. So, is there some way that you can relocate that in the time being, before the first of the year?
I'm gonna try to get it all over. I'll just take it to the recycling cycle yard and just get it separated or whatever. So
Okay,
that's the biggest problem. I use separating the stuff from it. So I'm just load it on the trailer and get rid of it.
okay, and then the other side of the problem is, you understand that the trailers and the boat
The
are,
boat is no longer there.
well, I
I know,
know,
but
I'm getting to that. The trailer and the boats are considered a recreational vehicle, each one of them. So the ordinances say you can only have one recreational vehicle in your yard. Okay, how do you plan to move your trailers or relocate your trailers?
I moved the trailer someplace else.
Okay, but you have a place in mind that you can do that?
Yeah, I'll take one of those trailers, not mine. I just have one trailer.
Okay, so it's doable, it's livable then?
I'm gonna be I'm gonna get it done.
Okay,
I'm gonna do what I have to do.
okay. Because we're trying to come up with something that's fair to everyone involved here. And that's the hard part, right?
I didn't understand.
I'm sorry?
I didn't hear you. What you
Oh,
said.
we're trying to come up with something that's fair for everyone involved, or a decision that's fair for everyone involved, and that's the hard part here. We need your help in that.
I'm gonna work on it.
Okay, great. All right, thank you, I appreciate it.
Any other questions for the respondent before he takes a seat? Okay, all right. Well, you can have a seat now. Thank you. Okay. Do we need a summary? Do you want to summarize city on anything?
No, thank you.
Okay, no, thank you, okay. I believe we've heard final comments from the respondent at this time as well. No public comments. If I could get a motion from one of our board members, once we have a second, we can have a discussion.
I move that based on the testimony and evidence presented and based upon these findings as a matter of law. What's that? Oh, repeat, okay, sorry. I move, okay. That the respondent, Mr. Evans, was in violation of sections 5.26 subsection 1 and subsection 4. And to section 23.12 subsection C of the Safety Harbor Code of Ordinances from the initial date of August 18th, 2023. And has until December 29th, 2023 to bring the property back into compliance for a fine of $250 per day will accrue from the date of August 18th, 2023. In addition, I move that the city be awarded $410 for the costs incurred in prosecuting the case. Let's see here. Okay, and that's it. Yeah. Thank you.
So we have a first, do we have a second?
I'll second it.
We can have a discussion, and so you know, Mr. Hack, how we do our rule of order, the person who does the first motion is the first person to discuss, and then the second, and then anybody can discuss.
So, this case, it was one of a series of cases that we heard that had kind of a trend that I spotted early on, and I gave the respondent, I think it was like 6 months to clean up, because it was like middle of summer that he was going into this, and it was miserable already. I think that the respondent understands that he can't run a scrapping business in a residential neighborhood any longer. And I'd like to see him get a little bit of time, because I'm balancing the interest of, I don't want to see the city in a position to put a lien against the property, which is going to be his primary home. It's not homesteaded, so he doesn't have homestead protection. So I'd like to see us avoid a situation where the city is in that position and puts everybody in a tight position.
I agree with that, and the city did help on October 6th last year, where the city manager did remove a lien on that property once before.
Yeah, and I don't think that they would be amenable to removing a secondary lien. Yeah.
For the second, Mr. Dahl, if you had anything to add.
I just have a question, Mr. Hicks. Why, I think you answered it when you gave the date of 29 December, in order to provide the respondent time. And I think
Oh, okay.
Do we need to have, I was going through all of this for the city had said that if we do not, if the property is not into compliance by the new date, December 29th, the city had asked that we go back to the 18th. That automatically happens of August. We don't have to read that into the motion.
It was read into the motion.
Did you say the 18th? Okay.
was read into-
So I missed it.
Yep.
Very good. Okay.
I had to cobble it together, but
I was looking for that. I was like, is this one? Okay, very good. Okay. The original motion was $50 per day, and the minimum on the repeat is $250. So, just,
Well, let me just clarify that.
is that true?
The fine can be up to $500 a day. It doesn't, there's no minimum, okay?
okay.
So the request is $250,
Okay.
there's no minimum.
There is no minimum?
No.
Okay, because the original one was $50 a day.
Right.
So it went from 50 to 250, so for trash.
And it could go 500. It's a repeat violation, right?
Any other discussion now that the two gentlemen have with their motions? Okay. Thank you, gentlemen. Ms. Bandy, for a roll call vote, please.
Beth Cardenas?
Aye.
Carmen Lundy,
Aye.
Neil Hicks?
Aye.
Christina Jackson?
Aye.
Jeff Dahl?
Aye.
Tom Shea?
Aye.
Brian Hack?
Aye.
Motion passes 7-0. Mr. Trask, could you please do a detailed summary for the respondent?
So, Mr. Evans, you've been found in repeat violation of the code sections that were cited in the code violation notice. That was section 25.26, subparagraphs 1 and 4, and section 23.12, paren C. You've been given until December 29th to bring the property totally into compliance. If you fail to bring the property into compliance by that date, you're going to be fined $250 a day, beginning August 18th. The Code Enforcement Board has also authorized the city to be reimbursed for prosecution costs of $410. This will all be reduced to writing like the last time, and you'll get an order written, and it'll be provided to you at the address that you live at now. It'll be sent to the address of the property that we're talking about, which is 660 Pine Street. So make sure your mail gets forwarded there. If you have any questions as to what happened tonight, you can contact Code Enforcement after the meeting or sometime during the week, okay? All right.
Are we ready? Gonna go to case number 2 under new business, CEB 23-0204, City of Safety Harbor versus Paul D. White, 645 Second Avenue North.
There is no respondent this evening for this case. Good evening, my name is Paul Bushy, Community Compliance Officer for the City of Safety Harbor. I am state certified in the fundamentals of code enforcement, administrative aspects of code enforcement, and the legal aspects of code enforcement. This case, number 23-0204, involves the property at 645 2nd Avenue North, Safety Harbor, Florida. The city offers printouts of the entry of this property from the Pinellas County Tax Collector and Property Appraiser's websites and evidence. Printouts show the property is owned by Paul D. White. This is not a homestead property. I'd like to enter the evidence, the property appraiser's report, and the tax collector's report.
Board accepts.
This property has been a significant source of blight on the city and the neighborhood since at least 2020. It has been vacant since at least 2020, with an absent property owner who apparently lives out of state. There have been multiple and consistent complaints from neighbors about rats, overgrowth, and odor emanating from the property. The board found the property owner in violation of section 5.26, overgrowth, at its November 6, 2022 meeting. The city subsequently abated that violation due to a history of no contact from the property owner. In addition, the city has abated overgrowth violations for grass exceeding 12 inches at least 4 times since 2021. The last payment against the past due utility bill was made on July 13, 2020. With at least 5 letters of abatement, in addition to the notice of violation and notice of hearing, board orders, lien notices, and utility bills, most mailed USPS certified, many with copies USPS first class. To contact the property owner by phone, there has been no response from the property owner except for one brief phone call with code enforcement, all of which have resulted in little to no efforts to bring the property into compliance. Little to no maintenance has been performed on the property save the abatements ordered by the city. Utility service to the property remains off and has been off since the turnoff order was issued on July 13, 2020. Section 11.2, subsection A reads, "It shall be unlawful for any person to live in, own, lease, maintain, or control any temporary or permanent quarters, either stationary or mobile, within the territorial limits of the city without having, providing, and maintaining adequate sanitary facilities." The respondent does maintain and control the property. The property has been without utility service since June of 2019, rendering the property without sanitary facilities as defined in section 11.02. The city will ask the board to find a respondent in violation of section 11.02A of the Safety Harbor Code of Ordinances. I'd like to present some photos. And they really don't show, it just shows the property, so you get a sense of what we're looking at, where it is. And also I have the utility statement showing the turnoff order on 6/20/2019 with the board's approval.
Board accepts.
Property prior to the last abatement that we had to do. The grass, it grows, it gets up over a foot. The neighbors are aware that the city is keeping an eye on it for the abatement. This is the result of the city hiring a private contractor to abate that nuisance. A notice of violation was mailed USPS certified, and a copy was mailed USPS first class, notifying the property owner of the violation on August 5th, 2023. The notice included the appropriate code sections and offered 26 days to bring the violations into compliance. The city offers the notice and the USPS proof of mailing into evidence with the board's approval.
Board accepts.
On October 6th, 2023, more than 10 days prior to today, Code Enforcement Board Clerk Elizabeth Bandy mailed a notice of hearing to Paul D. White, certified mail, with an additional copy mailed USPS First Class. A copy of this notice was also posted at the property, and an additional copy was posted at City Hall. The notice cited the appropriate code sections and the date of the hearing. The city offers the affidavit of posting, the notice of hearing, and the return receipt of the USPS proof of mailing and evidence with board approval.
Board accepts.
The property remains in violation as of this morning, October 18, 2023. Costs to prosecute include at least 9 hours of the code compliance officer's time and at least 16 hours of the code enforcement board clerk's time, for total prosecution costs of at least $410. The city asks the code enforcement board to find the property owner, Ike Evans, Paul D. White, in violation of section 11.02, subsection A of the Safety Harbor Code of Ordinances. It is the staff recommendation, in addition to the prosecution costs of $410, the city asks the board to find a respondent in violation of the above ordinance and allow an additional 30 days to bring the property into compliance. If not achieved, impose a fine of $100 per day, starting on November 17, 2023, and continue until the property has been brought into compliance. Thank you.
Mr. Bushy, we have some questions.
Sure.
Chair recognizes Mr.
Mr. Bushy, the city is only pursuing a violation of section 11.02A and not 5.20A or D?
Correct.
Why would those two?
This requires the, if you notice the language about a building official, so I do not have those qualifications to make that call.
Okay. And secondarily, considering the lack of communication by the respondent in prior instances, as well as the city having to take initiative to bring the lawn and the property back into compliance, why the 17th? Because that will leave the board not hearing this matter until December for the non-compliance, or compliance, whichever it may be.
Yeah, I'm just thinking reasonable time to bring the property into compliance. By the time we send notice and if he is reading the notices, he'll have some time to give the city a call. I know he has been in communication, so just to provide that information for you to make a decision. He has been in communication with the finance department about the water bill.
Okay.
So he is aware of these violations, both through the finance department and through code enforcement.
Okay. Thank you.
One question, if I may.
Chair recognizes Mr. Shea.
So is the city having to pay for the yard cutting, or did he do it?
No, the city has done it. The city hires a private contractor to do that, and then the costs are attached as a lien against the property.
So we're not asking for those costs now, or?
No, those are liened against the property.
Those are already liened,
Yes.
okay.
We could bring the case to the board as a repeat violation each and every time, but it's just not fair to the neighborhood. By the time we do it, and then we have it to the board, we're dealing with 2-foot tall grass. And,
right.
Several residents have related stories of rodents. I've been unable to see them, but they've showed me video, but they're unwilling to come to the board to authenticate the videos. So, but I am aware of the significant issues there.
Mr. Bushy, could you please clarify for this hearing? It is only section 11.2, which is the sanitary facilities required.
Yes, just subsection A. B is more descriptive. B does speak to the sanitary disposal of sewer and the disposal of solid waste, and without water service, you do not have those sanitary facilities.
Okay, thank you. And then Mr. Bushy, is my assumption correct that the 30 days is to help render the property to come into compliance? Essentially, they need to turn back on that utility,
Correct.
and then they will be in
That would
compliance?
put them in
Is my
compliance.
assumption correct?
Yes.
Thank you. Any other questions from the board?
Thank you.
Okay, thank you. No summary on this? This time, could we have a motion from a board member, please?
I move that based on the testimony and evidence presented and based upon these findings as a matter of law, that at the time of the alleged violation of section 11.02A of the Code of Court Ordinances of the City of Safety Harbor was in force and effect, the respondent was in violation thereof. The respondent shall have, excuse me, until the 9th day of November 2023 to come into compliance with the code or a code section, or a fine of $150 per day shall be imposed for each day thereafter the respondents remain in violation of said code sections, and to award the city $410 for the costs incurred in the prosecution of this case.
I'm sorry, Mr. Hicks, what was the date
I'm sorry? 9th
of?
November 9th.
Once we have a second,
I'll second.
Mr. Dahl did the second, Mr. Hicks for the first.
Go ahead.
Go ahead with your discussion.
So I know the city was asking until the 17th, but my concern is that we wouldn't hear that until the 20th if we have a meeting in December. It could get skipped, and that was a major concern, considering that the respondent hasn't been in communication with the city or had a spotty history. They also, as according to the testimony, they didn't mow the lawn. The city had to mow the lawn and then place a lien against the house, so they're kind of recalcitrant, in my opinion. And third of all, in this situation, all they have to do is turn the utilities back on. And then on the other side of it, the neighborhood side of it, I know that we haven't seen any evidence of rats or anything like that, but Mr. Bushy did state that the neighborhood and the surrounding neighborhood has said that there were rats that emanate from the property. It seems like this property's been abandoned, and I'd like to incentivize this person who doesn't own it as a primary residence and doesn't keep it up to keep up his property, because it's just unfair to the other neighbors in that area.
No, I have nothing further.
Any comments from other board members,
I have
discussions? Chair recognizes Ms. Lundy.
I mean, I respect what the city is asking based on time. I mean, for them to give notice, for the opportunity to respond to a notice. I'm assuming that we always have the right to back, say we come in December or whatever, and there has not been any compliance or whatever. Are we able to backdate any of the fines?
And
The compliance date would basically be set, whether you hear it in November, December, January, or on. The compliance date would be set, you just wouldn't have the hearing on it for that period of time.
Okay, so we can have a compliance date, even though we don't have a hearing. So why not give, as the city recommended, the time for the, mailing and notifications and things like that in all fairness?
Well, because in my mind, the mailings go out pretty quickly. They go out like pretty much by the end of the week. So if that's at the end of the week, the respondent should have that mailing by the middle of next week. And all they have to do is turn on their utilities. That's all the city's asking them to do, is just turn on the utilities to the property.
So in bringing it to the 9th, what do you expect to happen to make this, I mean, the city's taking care of the grass, that's not even before us anyway. So it's not even for us to have a decision based on that. We're basically talking about, I'm assuming, just getting the water on. So what difference does it make if we do the 9th or the 19th,
17th.
17th?
19th is Sunday. In my mind, it steps up compliance on their part. It makes them, puts them on notice that we're serious and we want you responding to this now, before we go into the holidays, because we wouldn't hear about it till the 20th, if then. And yes, we can always extend, it, you know, if we come in on the 15th and the respondent appears or sends in some kind of correspondence that explains their situation and asks for more time, we can always extend the compliance date out, just like we did earlier tonight. But I think they need to be incentivized to not let the city take care of their property. And, you know, when I hear about rats and other kind of pests coming out of that property, it's a serious matter. We're moving into wintertime, and the rat problems get worse because they tear into people's houses. That's it? You're going easy on me tonight.
I'm just gonna,
Mr. Shea?
I'm gonna play a little devil's advocate with you, because recently I've seen mail getting delayed a week, 2 weeks. Sometimes just going out of my office, it takes sometimes 10 days, 2 weeks lately to get mail, just the other side of the state. This is going to Maryland. That's my only pause on that.
So if we extend to the 17th, and you're saying 2 weeks, that would give them 4 or 5 days.
Yeah.
8 more days.
It would give them 5 more days to react. But we wouldn't hear about this until at least the 20th of December.
But the fines, if any, would already be starting to incur.
Yeah, the fines would start to occur, but we wouldn't find them in non-compliance until the 20th at the earliest.
Wouldn't discuss it,
Well, we
right,
wouldn't- we wouldn't
discuss it,
discuss
We
it.
wouldn't
right,
discuss
but the fines
reducing
would
it or
still
anything
start on the
until the
15th,
20th.
17th, yeah.
Yeah, and my goal here is to incentivize the respondent to contact us or to come into compliance immediately. I mean, we're at all
Hey,
there.
that's not an incentive if you don't get the mail.
Well,
I'm just gonna say is I know the city asked for, 100 or 150, I'm just, because of the repeat nature of violations, do we incentivize it by increasing the amount even more? And in my opinion, that would be, now, I was just looking, he hasn't paid taxes for 2 years.
Right.
there's that too, yeah.
Got numerous liens already. The motivation,
This is an abandoned property,
Yeah,
so I'm not a betting person, but I have to bet
I don't
that-
think it'll be fixed.
I don't think it will be fixed, and I think it will be more apathy-driven than issue-driven.
compulsion is to get them to sell or take some sort of action, I would assume, right?
Take action, yeah, take action to fix their property, bring it into compliance, or in some way not leave it in an abandoned condition. You know, I mean, we're talking about rats, you know, but there was also another case where we had a squatter in a house.
Oh, yeah.
And that person has been evicted, so that means they're looking for a place. You know, and it's just an attractive nuisance.
Julie, can I ask a question?
Of course.
You have a motion out. Sounds like there's some contention about the dates. Do we have to vote on that motion before another motion could be presented with alternate dates, or is there a way to negotiate this?
I could change the date.
We do some, so like, as the chair, depending on how I feel, some people might vote, I might say, hey, well, what if we change the date, or what if we go this way? But if because I always want it to pass unanimously, or pass to get compliance. If I feel like we're not gonna have the votes, then I
That
might
was
say
my
something.
question. So it's
Yeah,
a one shot, like if we don't.
correct. It's either gonna pass, we vote it up, or we vote it down.
Gotcha, there's no additional amendments that
Correct.
could be, or
Well, no, I
motions
can-
that could
Yeah,
be.
he could amend it,
I
but
can
the way,
amend mine,
the way it's
yeah.
going right now, I would feel comfortable calling a roll call vote. Based on how I'm hearing the
Making sure I
discussion.
understood the logistical
Yeah,
process about
but
what happens. if
we
it
always
didn't
want to
pass.
get compliance, but, you know, if someone's comfortable based on 6 days and they're gonna go nay, that's their right to go nay.
Right.
But then we risk the whole thing going nay. But you know, so,
Gotcha, that was, I think, the
Yeah,
logistical piece. of
exactly.
Could you come around
So you kind of
again
have
with
to
a-
like
an alternate
weigh
offer?
that.
No negotiations, got it.
But you can, he can absolutely amend his motion.
But it's the one motion. This is it, it's the decision on the whole thing.
Correct.
Got it.
Once we go to a roll call vote,
what I was
sometimes I'll say unanimous, because I'm like, okay, we're good. But in this case, we would definitely do a roll call vote.
So what dates are on your minds, Ms. Lundy?
You talked about the mail, Mr. Shea?
I would say 30, I would say reasonably, 30 days is a reasonable amount. I wouldn't go
Compliance
less.
date on the 17th of November. Okay. Ms. Lundy? Okay,
With the $150 per day.
with $150 per day, correct?
Yeah, I don't think, my gut says we should go higher, but he hasn't paid taxes. I don't know if money's gonna incentivize it
Yeah,
or not.
I doubt that's the incentive
That's
here.
not the-
And then why punish another buyer down the line with that much more fines that have to be paid off at closing?
I just like the good conscience of knowing that we was fair and giving him the chance to at least get the notice.
I think I'm sorry if I'm stepping out, but yeah, I
No,
think
no, no.
30 days is a reasonable amount.
Okay, all right, I'll amend my motion to compliance date of November 17, 2023.
And I'll second your amended motion.
Fine stays.
Fine stays with the 410, yep, with the original city ask of November 17th, so. Ms. Vandy, can we go to a roll call vote, please?
Yes. Beth Cardenas? Aye. Carmen Lundy,
Aye.
Miguel Hicks?
Aye.
Christina Jackson?
Aye.
Jeff Dahl?
Aye.
Tom Shea?
Aye.
Brian Heck?
Aye.
Well, motion passes 7-0. Let the record state. No need for summary. No one's present.
Okay, we're gonna go to compliance hearing. CEB 23-0098, City of Safety Harbor versus Stephen R. Butler, 126 Kendale Drive.
Okay, so for my signature, it's this one.
I would do it.
My name is Paul Bushy, Community Compliance Officer for the City of Safety Harbor. This is a compliance, affidavit of compliance, so I'll ask the board to accept for case number 23-0098. And I have the affidavit of compliance to present to the board with the board's approval.
Board accepts.
Motion to accept the notice of compliance in CEB 230098.
I second.
Okay. First and second by Mr. Hicks and Mr. Dahl. All in favor?
Aye.
Motion passes 7-0 for the record. And then I believe I just have one left.
Okay, we are going to non-compliance hearing number 1, CEB 23-0141, City of Safety Harbor versus Luther Graham Estate, 1340 Cedar Street.
Good evening, my name is Paul Bushy, Community Compliance Officer for the City of Safety Harbor. I would ask the board to accept the affidavit of non-compliance for case number 23-0141, it's 1340 Cedar Street. I'd like to present the affidavit of non-compliance with the USPS proof of mailing, the board order, the notice of hearing, and the affidavit of posting, again with the USPS proof of mailing. And there's also a letter that was mailed to our code enforcement board clerk from a distant relative. I believe he is Ms. Bandage, correct me if I'm wrong, an uncle. And I would ask the board if they would wish me to read the letter. Okay, Tom.
Leave the letter, they can pass it and they can read it themselves. It would just take a lot longer if everybody read it individually. So why don't you read it out loud?
Thank you.
Yes.
You can do that.
Mr. Trask, did you need to see the letter, or does the city see the letter as
the
evidence?
city
You've
is-
already seen it?
The city's
Okay.
proposing
Have-
it,
Do you
so-
need to see? Okay.
If the board wishes, I would read it. If the board doesn't wish to hear it, then
I would like to hear it. I just want to make sure we go through the right process, so.
understood.
Okay.
And,
Accept the evidence.
Yeah.
the board accepts the other.
We accept that evidence, no problem, absolutely. And then as long as the attorneys agree on the letter, if you need to see it first, like, no cursing, no nothing bad. Yeah, you've already read it. You're good.
This was addressed to Ms. Elizabeth Bandy, Code Enforcement. And
What are you
it's
reading?
RE Estate of Luther Graham, 1340 Cedar Street, Safety Harbor, Florida. Code violation of sections 5.20 A and D and 11.02A of the City of Safety Harbor, Florida. Initially outlined in a letter dated June 29, 2023. Dear Ms. Bandy, I hope this letter finds you well, and thank you for taking my call yesterday and sharing information about this very important matter. The family is writing to formally request an extension for the correction of a water code violation that has been brought to our collective attention. Please note that post receipt of the code violation letters, we have been diligently working to rectify the situation. However, due to unforeseen circumstances, we require additional time to ensure that the necessary measures are in place to fully comply with the water code. Also, due to our dispersed geographical positions and exorbitant cost of travel, we will not be able to attend in person the hearing scheduled for October 18, 2023. So please accept this formal request for an extension. However, I, Gerald Malloy, can be reached by phone at, and this is phone number. The specific violation relates to a former unpaid water bill, which we have attempted to pay in the past, but your office would not permit payment until resolution of the family estate has occurred. Please note that we take this matter seriously and are committed to resolving it as promptly as possible. As we are attempting to work with an attorney to successfully finalize the estate on our behalf. Therefore, we humbly request your consideration of this extension request. It is our intent to continue working diligently and transparently with the relevant agencies to ensure that the violation is fully corrected by the extended deadline. Thank you for your understanding and consideration of this matter. We appreciate your cooperation and look forward to resolving this issue to the satisfaction of all parties involved. Sincerely, Gerald Malloy, family of Luther Graham. I would like to note to the board that I do appreciate Mr. Malloy's efforts and interest in this case, but I did check the probate record, and we haven't even started the probate filing. This property is, again, a significant source of light on the city and the neighborhood. We received quite a few complaints on it. I just couldn't get behind an extension for the court's order on the property.
Thank you for reading that into the record for us. Mr. Bushy? Am I allowed to make comments for the board on what this case was? it's a non-compliance, so we're not relitigating it, just so they know what it was, based on
Yeah,
that letter.
Mr. Bushy can do that.
Mr.
Let him
Bu-
testify about that.
Yeah. Will you, good evening, Mr. Bushy.
Good evening.
Could you please, for the record, confirm my recollection that I'm trying to say it in the form of a question, that we passed a motion stating that the respondent should have until midnight on August 30th to come into compliance,
That is correct.
or a fine of $100 per day would be imposed on the section 5.20 A and D and 11.02, that's the sanitation one about the water.
Good.
So the affidavit of non-compliance is for both of those. So the non-compliance hearing, if you could just state my recollection is correct, yes or no?
That is correct.
Okay. Do you have any questions?
Is that the property that the attorney came and they were talking about they were gonna sell it or something?
I don't think he's an attorney. I think you had a relationship with the family. I'm not exactly certain what the relationship was. They cannot sell it until it gets through probate. There was some talk that they were going to start a probate process. And again,
You say it was already going on. I thought he said at that point.
they hadn't started anything, and like I said, I looked up the
Okay.
case on Monday. Nothing's been filed.
So they haven't even, I'm sorry, I didn't mean to
No,
jump
no,
over.
no.
Mr. Bushy, they haven't, the respondent hasn't taken the 2 months that we gave them to get probate proceedings and get the quiet title action.
Nothing's been entered into the court record.
Okay, okay. All right, thank you.
So have you spoke with, I'm sorry, what? Have you spoke with them? Maybe they're trying to do it in another family name?
I haven't spoken to anybody there. There's no longer anybody at the property as far as I know. And I'm not aware of their relationship with the deceased Mr. Graham.
Mr. Bushy, I don't think that this date is correct. Can you please state the date of that letter again? The letter?
October 13th, 2023.
Like a couple days ago.
Monday.
Thank you.
Thank you.
Thank you.
Motion to accept the notice of noncompliance in CEB 230141.
I'll second.
Okay. We had a first motion from Mr. Hicks to accept the affidavit of noncompliance, and then a second from Mr. Shea. We could have a discussion if we would like to, or I will take it to a roll call vote.
I guess I can start. So we gave the respondent sorry, I grabbed your calendar. We gave the respondent 2 months to start a quiet title action in this case. I know you weren't here for that.
I
That's
watched
why-
the video.
Oh, you watched the
remember this
video,
one.
okay,
Yeah.
so you read
Yeah,
in.
I know this one.
Okay, okay. And we tried to come up with a way forward. They said 2 months, and I believe we gave them 2 months to come into compliance, and now we're on month 4, and we didn't get anything until Monday. I think they knew that this was coming. They just are kicking the can down the road. While I'm sympathetic, I think they have to take action on that property sooner rather than later.
Thank you, Mr. Hicks. I appreciate that. The second, do you have any comments? If not,
I mean, this is one, all they had to do is restart the water.
Yeah.
Well, it was about just restarting the water. They couldn't get the water started because the water was in somebody else's name who was deceased and.
The residents just up and left. Now
Yeah.
it's just up in the air and nobody wants to confront this problem. Yeah.
And I believe it had been that way a while. I believe the person had died a while back.
Yeah.
Like not even
Yeah.
not even within the last year, I want to say.
Aligned.
I was gonna say, it's just kind of sitting there in limbo.
If I remember correctly, it was over 2 years ago. There are proceedings that they could go and get the property transfer their name almost immediately at this point.
I appreciate the comments because of the letter, and they can watch the video and just hear from us, so I appreciate the comments, even though there's nobody physically here. Ms. Bandy, any other discussion from anyone else? No? Okay, we'll go to a roll call vote on this one.
Beth Cardenas.
Aye.
Carmen Lundy.
Aye.
Miguel Hicks.
Aye.
Christina Jackson.
Aye.
Jeff Dahl.
Aye.
Tom Shay.
Aye.
Brian Hack.
Aye.
Motion passes 7-0. No need for a summary on this one, I think it's. And thank you all. Okay, I believe that concludes all of the hearings, new and old, on the agenda. Nobody here from public audience. Board and staff comments. I would just like to say thank you again, and for watching all of our previous videos
I
and
did.
getting read in on that.
Thank
That's
you.
fantastic.
Wow.
I know. He's very eager to learn. That's great. And for jumping in instead of an alternate, like,
Happy
wow.
to help. Glad to
On
be
your
here.
first meeting. So thank you again, Mr. Hack, and welcome, welcome. Any other board comments from anybody else? Staff comments? No. Okay. Meeting is adjourned shortly after 8 o'clock, at 8:01.